Module J, the argument. Let's take a quick look at a few things we've talked about so far when it comes to creating and writing your arguments. First and foremost, you need to remember your overriding goal, and that is to persuade judges. How can you do this? Well, include an introduction that helps state your theme. Remember, every good brief should make its primary point within 90 seconds, but only about 1% of briefs actually do this. Make your arguments first, then go ahead and address your opposing counsel's arguments, or cases that have to be distinguished. Make sure to always lead with your strongest argument, and then your second strongest, and so on. As you do this, use headings and subheadings throughout your brief to help guide the reader. And make sure that you address weaknesses, especially if you are the appellant. You need to anticipate what the respondent is going to say. Why should you take the time to tackle the law that's against you and the facts that aren't exactly favorable? Well, think of it as the carrot and the stick. The stick are the rules of professional responsibility. The carrot is the opportunity to explain bad law or facts. This will help establish your credibility with the court by building a reputation for honesty. If you can show the court how to overcome hurdles and decide in your client's favor, then you're doing the right thing. You also need to know that you have to concede where necessary. This, too, adds credibility. And in the same vein, abandon losing arguments. These will negatively affect your strong arguments. You don't want to detract from those. And once again, it goes to your credibility. It's about logic. Logic and crack. Judges will look at your argument first and determine whether it even makes logical sense based on the language. Then they'll look at whether it is true under the governing law. Arguments that have both cogent reasoning and true premises are sound arguments. We talked about crack already. Follow crack with each issue or major point you make. For each point, you'll state the issue, the standard of review, although if it's the same throughout, you can just discuss this up front. You'll review the facts in a manner that reflects the standard of review. You'll cite the controlling case law, establish that it states the policy that appropriately applies to this case. You'll apply that law to these facts. Then you'll demonstrate that this application does fulfill the underlying policy of the law. You'll also deal with adverse precedent, show how it's distinguished and how its policy is not truly applicable to these facts. Then state the result of the application of the law to these facts in terms of the court's possible relief. It's about using the facts and using the law. Remember that judges want to decide your case fairly, but they also want to avoid creating a new rule that could be used in the future for something contrary to their intention now. Therefore, they want their decision to fit within the framework of the law. So don't emphasize the uniqueness of your facts. Don't announce that your case is a case of first impression, if possible. Rather, demonstrate how the result you seek is the logical or natural extension of the policy of the law. As I mentioned previously, as you state the facts in the argument, you can delve into greater detail than what you have in your statement of facts. If you do go into more detail in your argument section, make sure that you're citing to the record. Also, you need to be most careful when you're anticipating an opponent's argument. Keep in mind that a party is not required to espouse on appeal any legal argument it used in the district court. The judges are going to read the district court order. Answer that order. Focus on the crucial point where the district court turned against you and your client. If there is no applicable authority, admit it. Be careful of your discussion of cases. Do not overstate a case's holding. Do not quote from a concurring opinion and act as if it were the holding of the court. Do not use dicta as a statement of the court's holding. Respect the limitations that the opinion sets for its holding. Make sure you use secondary authorities correctly. Do not cite a treatise, no matter how respected, as the first authority for any rule of law. And if you do cite a treatise or something like that, try to provide a supporting case citation from your controlling law if possible. Be sure to analyze the case law. Don't just string cite it. Explain why the cases you rely on should control the case, rather than the cases your opponent or the lower court cites. Never use a long chain of cites. They are not impressive. Now, if you're dealing with the circuit split, then you'll probably have to cite several cases since each one is in a different circuit. That's fine because each adds to your argument. Be sure to read every single case that you cite. Always presume the 3 judges on your panel will read them and the authoring judge will study them all very carefully. Be selective about your cited authorities. Reject cases that are poorly written, have puzzling reason, or are factually odd. One strong precedent is all you need. Others detract. Less is more. What governs your analysis? If your appeal turns on a statute, regulation, or jury instruction, set forth the relevant portion of the text in a separate paragraph. When building the argument, quote only the words needed for your thought. Do not merely refer the judges back to the document on another page or in the addendum. Provide key words in quotes. Then, after you've quoted it, do attach a full copy of the appendix. Case law will then provide construction of the language of the statute. If the point on appeal rests on state common law, start with state cases. If there are no state cases on point, acknowledge this before discussing cases from other jurisdictions. The best type of case to rely on is a case with the result that you seek. If you don't have that, then use a case with good language that is distinguishable as to the result. Let's talk more about how you apply the law in your argument. Repeat the language of the legal test when applying the law to your client's facts. For example, the employer provided employee Smith with a meaningful opportunity to respond to the allegations against him because the employer met with Smith to permit him to refute the charges before the employer decided to suspend him. Make analogies between your client's facts and the facts of the decided cases. For example, like the unattached garage in Prigaroni, which was separated from the house by a walkway, in this case the trailer was separate from Mrs. Peluso's main house. Make distinctions between your client's facts and facts of decided cases. For example, unlike the attached garage and enclosed patio in Cook, which qualified as integral parts of the main house because they were akin to additional rooms, here Mrs. Murray's trailer does not share any door with the main residence. And make it easy for the court to see that the result your brief advocates for is consistent with binding precedent. For example, the public policy served by considering the attached garage and patio in Cook to be part of the inhabited dwelling house, which imposes a more serious sanction for the crime of burglarizing a place likely to be populated, would not be similarly served here by expanding the definition to include the trailer. What about making your conclusions? Why should you win? What relief are you seeking? Tailor it to errors. Tell them exactly what you want. Tell the judge in no uncertain terms the result you want, including alternatives. For example, for all of these reasons, summary judgment should be entered in the appellant's favor. In the alternative, this court should summarily adjudicate each separate cause of action in the appellant's favor. Be very specific in what relief you seek. It can be effective to recap the argument, but it must be extremely concise. And a recap is not always necessary. Examples include, for the foregoing reasons, appellant requests the court to reverse the judgment against him and remand the case to the district court for entry of judgment of acquittal. Barring that relief, he prays that the judgment be reversed and the case be remanded for a new trial. For these reasons, the judgment of the district court should be affirmed. For the above reasons, appellant requests this court reverse the judgment of the district. You can also use the conclusion to make a very short policy plea. For example, any other result would open the law to repeated, unwarranted claims. Overall, remember that a concise brief focuses the judge's attention on a few good arguments. Focus the court's attention on strong arguments by editing out words that do not advance your client's argument. Cut out the fluff and jargon. Aim to reduce average sentence length, paragraphs, and your overall brief.